Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. I accidentally hit the guy. They hacked the light using an AI.
Sir, Mr. Warren, the court, in listening to you, does believe that you would need a forensic evaluation.
No, I'm perfectly fine, Mr. Simpson.
Sir.
Before this hearing even begins, the courtroom is already heading toward chaos. What starts as a routine felony case quickly transforms into one of the most unusual exchanges you'll ever see. The defendant insists on representing himself, repeatedly interrupts the judge, rejects legal advice, and even argues against a forensic evaluation while making a series of increasingly extraordinary claims.
Mr. Wara, state your name for the record.
Joshua Wara.
All right. And this is the date and time I had set preliminary examination in this matter. My understanding is you would like a forensic evaluation.
That is correct, Your Honor. Based on my conversations with Mr. Wara.
Forensic evaluation for what? What's going on here?
Based on my conversations with Mr. Wara, I believe that it is necessary.
Hey, I'm representing myself. What are my charges? What am I in here for? I'm representing myself. I don't need a barcode to represent myself. What am I in here for? What charges am I on here for? I don't need a forensic exam. I'm not mentally disabled. I have ADHD and PTSD. I'm perfectly fine. I'm not on Social Security.
Sir, you are before the court on a felony complaint that alleges that on or about, as I read to you before, October 15, 2025, location of South Main Street and East William Street in the city of Ann Arbor, Washington County, state of Michigan, that you did fail to stop at the scene of an accident resulting in serious impairment or death. Individual.
The guy was perfectly fine.
That is a felony, punishable by up to 5 years incarceration and a $5,000 fine plus court costs. You do understand that, sir?
I understand that. Thank you, Mr.
Count 2 on that complaint alleges that on that same date and at that same location that you did commit a moving violation causing serious impairment of a bodily function. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. You understand that?
Yeah, I understand that.
All right. So that is what you are here for.
Mr. Simpson, I'd like to subpoena the camera footage from the mobile gas station there on North Main Street that I was at, or on South Main Street where I was at, over on South Main Street in Maynard. My car was parked there the whole time. I accidentally hit the guy. They hacked the light using an AI.
Sir, Mr. Warren, I'm going to suggest to you this. That refrain from saying anything, because anything you say can be used.
Oh, I know. They used an AI ethical hacking app, the Tomboys and the Ku Klux Klan, and they had broken my glasses when I wasn't. They took my car for a joyride and broke my glasses while I was at St. Joe's Hospital.
The Klan did?
Huh? Yeah, the Ku Klux Klan. You can subpoena video records, and I subpoena the security guards from St. Joe's Hospital, Trinity.
At this point, the hearing takes a dramatic turn. Notice what's happening here. Instead of answering questions related to the actual criminal charges, the defendant begins requesting an enormous number of subpoenas involving unrelated people, phone records, hospitals, correctional facilities, and other matters that don't appear directly connected to the preliminary issue before the court. Whether any of those requests ultimately have merit isn't the question today. The immediate issue is whether the defendant can rationally assist in his own defense and understand the proceedings taking place. This is exactly why competency and guilt are two completely different legal concepts. A competency evaluation doesn't decide whether someone committed a crime. It simply determines whether the defendant is presently capable of participating in the legal process. The judge is carefully observing not only what is being said, but how it's being presented. Every interruption, every sudden shift in topic, and every refusal to focus on the pending charges becomes part of what the court is evaluating. What do you think? If you were the judge, would you continue allowing the defendant to represent himself? Or would these repeated statements make you question whether a forensic evaluation is necessary before moving forward? Let us know your thoughts
Hospital,
below.
Trinity Hospital.
That's one of the reasons, sir. That's one of the reasons why you have an attorney. Did you let them know that?
No, I don't have an attorney. I told them I don't want anybody to represent.
wanna
I said I'm
represent
representing
yourself?
myself. Yes.
Is that what you want to do?
Yes, I would like to do that.
Sure.
And I would like to
I
subpoena
do
the camera
have to
footage from the
advise
mobile
you,
gas station
now
on
knowing
Maynard.
what the
South
charges
Main.
are, sir, that if you elect to represent yourself, you'll be held to the same standards as an attorney would regarding the rules of evidence and procedure in the courtroom.
Yes, Your Honor, I
And
understand
would
that.
not be shown any favoritism.
Yes, and I would like to subpoena my
If
discovery
at some
packet,
point in
please.
time you wish then to be represented by counsel, you need to make that request to the court.
Okay, I've
to
tried calling
do
the public defender's office and I've tried to tell them I want to represent myself. And I've tried to subpoena my discovery packet and they won't bring it to me. I need to subpoena my discovery packet for all cases available, please.
All
And I would like,
cases
yep,
only
and I
have
would like to
one. You have
also
more than
subpoena everybody's address in the MDOC that's involved in the Neuralink case through Secretary of State, phone numbers, text messages, and visual voicemail records. And I would like to subpoena the phone recordings, Securus GTL recordings from when I was in the MDOC at ARF level 4 and WCC pictures and.
Sir, I've listened to you both through the last hearing and this hearing. So what I'm going to do at this point is I'm not going to relieve the public defenders, but I am concerned, while you have indicated to me that you don't need a forensic evaluation, the court, in listening to you, does believe that you would need a forensic evaluation.
No, I'm perfectly fine, Mr. Simpson.
Sir.
Here's the pivotal moment of the hearing. Despite the defendant's repeated insistence that he's perfectly competent, the judge formally orders a forensic evaluation and refuses to remove the public defender from the case. That decision isn't based simply on the defendant disagreeing with the court. People have every right to disagree with judges. What concerns the court is the overall pattern displayed throughout the hearing, the inability to remain focused on the charges, the repeated unrelated allegations, and the courtroom behavior the judge has personally observed across multiple hearings. The judge even explains that the evaluation could ultimately benefit the defendant. If the evaluation concludes he's competent, the criminal case can proceed normally, and questions about self-representation can be addressed later. In other words, the evaluation protects everyone's rights, including the defendant's own constitutional rights. Instead of viewing it as punishment, the court is treating it as a procedural safeguard. Yet even after hearing that explanation, the defendant continues objecting and demanding immediate changes to his bond, showing just how far apart the two sides remain. The tension is now at its highest point, and the hearing still isn't quite over.
Sir, for your own
I'm not on Social
protection and
Security.
preservation of your rights.
I'm not on Social Security. I'm over the age of 25. I'm not mentally disabled. I do not need a forensic
And sir, here's the thing.
I do not
I
go
have
to the
to,
forensic center.
I have to, in terms of these proceedings, make sure that you are competent and
Oh, I'm very
no
competent,
link.
Cedric Simpson. You can tell. I'm very
Thank you,
intelligent.
sir.
I have a GED. I got a GED in 2013 in 3
Okay,
months.
all right.
I got a GED from Washington Community College Adult Transitions Program in less than 90 days in 2013. You can subpoena that record. If someone can get a GED in less than 5 months, I'm pretty sure they're competent. And I would like to subpoena my GED from the Adult Transitions Program in 2013 at Washington Community College.
Subpoena. I will not relieve the public defender at this point, but I will consider certainly that once the.
Thank you. Yeah, that way, if you see I got a GED from WCC in 2013 in 3 months, you know I'm competent. You know what I'm saying? Thank you, Judge.
I am going to order a forensic evaluation. I will set a competency hearing just to make sure. I'm going to set that for January 29th, 2025.
January 29.
a.m. I will sign an order to.
Can you give me a PR bond, please, Judge?
I'm sorry?
Can I please, I would like to request a PR bond.
This time you can file a motion, or somebody can file a motion before the court, and I'll consider a written motion, but this time I'm not going to change the bond in this case.
What is the bond?
Currently, your bond is set at $25,000 cash sure.
Do you have any bail bondsman numbers for me that I could get a hold of, please?
Sorry,
I'd like to subpoena a bail bondsman phone
check
number.
with the individuals at the jail. I'm sure they'll be more than happy to assist you in that regard. All right? So that you understand, I'm leaving the public defender on the case at this point.
No, I don't want a
Get
public
the
defender.
evaluation. I hear you, but I'm telling you what I'm doing. We will get the evaluation. I'd suggest that you be cooperative in that. You may be right, it'll come back competent, and then we can get this proceeding moving even quicker.
not gonna come back, huh? Y'all gonna try it.
Before we go off the record,
Y'all corrupt as it, y'all fucked up, people. Y'all people fucked up. Y'all,
Okay, keep moving. All right, been a pleasure.
I'm Benjamin Franklin's son.
Me too.
I just want to.
Because Paris is lovely in this one.
I just want to address one thing, Your Honor, relating to the prosecutor's office's responsibility of providing discovery as we move forward in this case. The defendant, in attempting to represent himself at the PCC on Thursday last week, stated that he didn't need an attorney, he didn't want an attorney, and that he didn't need the discovery either, that he knew what was going on, and that he wasn't worried about having all the video prior to today's hearing, and we were prepared to proceed today. At the same time, under normal circumstances, we would be in the process of getting all of that video discovery to defense counsel that he referenced wanting today. He mentioned wanting the video at the intersection. My office is in the process of getting that hopefully before the weekend. And I'm looking for permission to provide discovery to Mr. Brown's office on this file moving forward.
In response, Your Honor, as we are still on the case, I would ask that they provide discovery as they normally would.
And then if in January, depending on what happens, then certainly that information can be tendered either if he's going to represent himself, which he may be entitled to do, then the public defender can turn it over to the prosecutors we have in other cases can supply it directly to him.
Understood.
All right. Thank you. At least I wasn't called the Illuminati in this one. Well, that's also called a bunch. It was also called a bunch of other things, but that's okay. I'm good with that. I'm confident in me, so I. Was that your only case, Mr. Brown?
I think it's so long.
What we've just witnessed is a powerful example of how courtroom procedure often matters just as much as the criminal allegations themselves. The defendant faces serious felony charges involving an alleged failure to stop after an accident causing serious injury. But before those allegations can even be litigated, the judge determines that a competency evaluation must take place. The public defender remains appointed. The request to reduce bond is denied for now, and the case is postponed until the forensic evaluation can determine whether the defendant is legally competent to continue. Throughout the hearing, the judge consistently tried to explain the legal process while protecting the defendant's constitutional rights, even as the defendant repeatedly interrupted, made unrelated claims, and resisted the court's rulings. Whether viewers agree with the judge or not, this hearing demonstrates how courts must balance due process, public safety, and a defendant's right to a fair trial before moving forward with criminal proceedings. What do you think? Did the judge make the right decision by ordering a competency evaluation, or should the defendant have been allowed to represent himself immediately? Share your opinion in the comments below. And if you found this case as shocking as we did, make sure to hit that like button, share this video with friends, and don't forget to subscribe for more jaw-dropping courtroom breakdowns and real legal drama.